longtime friend of the program, Jack M. LaPedis. And his first name is Jack legally, at least it is on the calbar.org website. So many people name Jack, or really name Jonathan, they go by Jack, or they name something else and they go by Jack, John Kennedy famously. But at least the calbar.org really is Jack. We're going to talk about the importance of specific names. Local attorney Jack M. LaPedis. Jack, thanks for joining us today.
Thanks for having me. Always a pleasure.
So really, I'm kind of making fun of it, but the use of a middle name consistently or not can become important in estate planning documents and or real estate transactions, I would think.
Yeah, it can. It shouldn't, but it can. And the reason why I say it shouldn't is because you can sign your name however you want. You can sign it. I know someone who when they sign their last name, it's the first initial and then just a scribble. And so if that's how you sign your name, that's how you sign your name. Interestingly enough, I remember when I was signing documents for financial aid in law school, they had a specific rule that they had to be able to read your signature, which I thought was interesting because not every signature can be read. So if I'm writing a legible signature when I don't normally have a legible signature, is that my signature or is that me writing my name? So it comes up in that context, and as we were discussing off the air, the middle initial can be important. I always go by Jack M. LaPedis. As you mentioned, I had a grandfather who went by Jack LaPedis. Jack was not his legal name. It is my legal name. And because of some tax issues that my grandfather had at the time that he passed away, I've always used my middle initial because it's just to differentiate myself from my grandfather, from someone who doesn't do, if there's someone who decides to follow up on the tax issues and doesn't do their homework to figure out that my grandfather would be 120 years old today. So that's why the middle initial, I was the only kid in kindergarten who signed his name with the middle initial.
Wow. And it's important, I think, I had as I mentioned, a probate case where father and son had the same first name, same last name. One used his middle initial regularly, one didn't. And there was a deed between the two. The question was who was deeding to whom, who was deeding to whom, I think is the right way to put it. And that was the legal issue. And both sides had arguments to make and went to the judge, and the judge made a decision, and millions of dollars were transferred based on the decision. Whereas, you could say maybe one side would say it was purposely made unclear. The other side would say if you'd made it perfectly clear, we wouldn't have had this issue. So that becomes important in estate planning documents. I imagine when you leave, you have heirs. You want to name the heirs properly. If you're the trustor initially, you want to put your name properly. Make sure people know that. So that's just an interesting play on all that, I guess.
Well, the first thing that pops into my mind when I think about deeds is that's one of the categories of documents where you need a notarized signature. Mm-hmm. And the notary typically has a book where they write down not just the person's name, but they take their driver's license number and a fingerprint.
Right.
And I've handled a number of cases involving notary fraud and notary negligence. So that doesn't always happen, but that's the whole purpose of a notarization is to identify who's doing what.
Right. Theoretically, I mean, it's only as good as the ID and the notary, and like you say, I've been involved with the notary fraud cases as well, and so that's just if they're going to steal somebody's property for $1 million, they'll probably also falsify the notary documents. I mean, if you're at it already. So one of the things I want to talk about, and I find that you always have good insight on, is the issue of partition and a partition action. For those who watch, and I talk about this more regularly now, and I have a new podcast I just launched called Fractional Interest to discover it in more detail. But it has to do with when you have two parties on a property, oftentimes it's misthought that the majority owner has more rights or can make the decision if they're going to sell or not sell. In reality, I believe, and you're the attorney, I believe that either party can force a sale under certain restrictions using a partition action in California. So talk a little bit about if somebody is either an equal or minority partner, besides, just being bullied into acceptance, what are their options and how hard is it to do a partition action?
Well, let me go back even further. I have come up with this rule of thumb. If you're going to own property, real estate, with somebody who is not your legal put a ring on it spouse, you need some sort of written agreement. And whether that's a direct written agreement, like an operating agreement or a management agreement, or the formulation of a LLC or corporation that has its own agreements, that answers those questions. And people are like, oh, well, this is my best buddy from first grade, and we've always been, whatever. That's fine and good, but what happens if your buddy dies? Now you're in business with his wife that you never liked.
Right.
And operating agreement or the corporate documents will say what happens if someone dies, what happens if someone wants to get out, what happens if someone loses their interest due to a judgment. I mean, there's all those things a lawyer can help put together. And you don't talk to a lawyer to tell you everything that can go right. The lawyer's look into all the things that could possibly go wrong, and we'll cover that. So assuming we don't have that, and you have people who own a piece of property who are not spouses, and something happens with the relationship or whatever, uh, unless the deed says something different, everyone has rights. A lot of things, one of the main things a lot of people don't even realize is that if you are part owner of real estate, you can live there rent free unless there's something in the deed or some agreement that says otherwise. So you get into a situation where two people own a house and one person lived there for 20 years rent free, and the relationship is breaking up, and the other person says, okay, well, you owe me 20 years worth of rent. No, you don't. So, it arguably someone who owns more of the property uh, may be able to impose their will on someone else to some extent, but it's not absolute. And it certainly isn't absolute when it comes to selling the property or keeping the property. So if there's anyone who owns an interest in the property, generally speaking, they have a say in what happens. And if the relationship really breaks down, what you end up doing sometimes is you have a partition action. And a partition action is literally a lawsuit where one or more parties sues the other owners and says, I want to sell the property and split the proceeds. Period. The end. So if you have a partition action and it goes all the way through trial, at the end of the trial, the judgment will be the property will be sold, and this is how the money is going to be divided. And there's not much more to it. Uh, so you have situations where these partition actions, in my experience, almost never go to trial. They're really just a way to force a settlement of some kind. And a lot of it comes down to math. If one party has been paying the electric bill the whole time, they're entitled to reimbursement for half of that if it's them and one other person, or however many people there are. If one party's been paying the mortgage or the interest, or the mortgage or the insurance or repairs, the gardener, anything like that, uh, a partition action will involve accountants who will figure out who owes who what. If you own the property 50-50 with someone else, it's not as simple as saying, okay, you get 50% of the proceeds and I get 50% of the proceeds. Someone's been paying on that, and if they haven't been paying equally, someone should end up with more money. Now, what typically happens is some sort of settlement, and maybe there's a reason why someone doesn't get 100% of what they would otherwise be entitled to. Uh, and then you also have a situation where someone sues for partition really just to get bought out, and the other party, says, "Well, I don't want to sell the house. I'll, finance buying this person out, and we'll come to a number. And again, you don't always end up with a 100% of what you would typically be entitled to if the case went to trial and you really figured out the numbers. So a partition action is really an action by one party to split up the property, break it down into dollars and cents, and resolve the partner or dissolve the partnership. You're muted. Bill, you're muted.
I don't know how that happened. I'm sorry. I was coughing or something. Does the court have a process like probate where the court supervises the sale, or does the court just order that it be sold and they appoint a real estate agent, or do they both parties have to agree? What's the process for the property? So I've seen cases where one side brought an offer, and they brought an appraisal and said we want it sold for 1.3 million, and we're entitled to half or third, and the other party has the right, I guess, to match that. What's the process look like if it does go to trial?
If it does go to trial and a judgment is entered for the sale, the judge can order whatever they believe is reasonable. Typically, the parties will put forth what they want to happen, and may even propose, who the real estate agent would be. So the thing to keep in mind, though, is the possibility of any civil matter going to trial is very, very small.
Correct.
The likelihood of a partition action going to trial, and to be honest, I've never had a partition action go to trial of one of my cases. And I don't know of any other lawyers that I know who have taken a partition action to trial, at least in LA County. I'm sure they do. At some point in time, you get parties that just aren't going to do it,
right?
Aren't going to resolve it, and so they have to go to trial. And I'm cognizant of the fact that most cases don't go to trial, but I prepare every case like it's going to go to trial. Partition actions are probably the least likely to go to trial of all the kinds of cases that I handle. And I can say that with some surety, because I was just in trial the last 2 months of a case. I was like, there's no way this is going to trial. This is going to settle. This is going to resolve. But it went to trial. We were in trial for 2.5 weeks. Partition action, if I have a partition action that's going to go to trial, I'm buying a lottery ticket.
Well, I think now my experience with this on the other end is that you never get the other party to agree based on a phone call or based on a strongly worded attorney letter that what always triggers the settlement. And I think you're right. I've not personally been involved in a partition. I've interviewed other attorneys who've done some, but it seems to me it's one of those matters that you have to follow the petition to get the other side to take it seriously, because then they have to turn around and hire an attorney, which is writing a check for $10,000, $20,000, I imagine, and start working on defending themselves. And short of that, my experience is the two parties aren't communicating. There's nothing that will get them to, and I've had two of these recently, and even the letter from the attorney outlining what the code says, and you're going to lose, and you have to pay the attorney's fees back because you didn't agree to sell the property as required. It just seems that the only way anything gets triggered is the actual filing of an actual petition, which is a real waste of money and time and effort. Is that your experience, or have you been able to get people to recognize their limits via a phone call and/or strongly worded attorney letter?
I have a limited view of the world. Okay? By the time something comes and hits my desk, things have already gone wrong for the most part. By the time someone calls me about the situation, they've already tried to resolve the situation with the other side, and the other side is just being whatever. So by the time I get it, we're already down that track. Now, that being said, as with all my cases, if the litigation has not already been filed, one of the first things I do is I write a letter, and I specifically am excluding saying a strongly worded letter. I write a letter like you described, that just the facts. You know, the property is worth this much. This is who is paying the mortgage. This is who is paying the insurance. Here are some round numbers, and basically, please get back to me. Like that's my first letter is get back to me and let's see what we can do, or have your lawyer call me. And then I usually, if I don't hear anything, I'll follow up with another letter, and then if we can't resolve it after two letters, or if they're not getting back to me, then we have to file a partition action. A lot of the partition cases that I've handled in the last 8 years, I'd say about 80% of them were already in litigation by the time I got involved, and which I think is unfortunate because you're right. It's a big waste of time. It sets artificial deadlines. The attorneys have to do certain things, whereas if you just look, if you're going to file a lawsuit, tell the other side you're going to file a lawsuit. You better go hire a lawyer. Let's have our lawyers talk before we actually file the documents.
Right.
But that's logical thinking, and that's lawyers don't make a ton of money that way, but that's the way I like to try and handle things. I like to give people the opportunity to avoid litigation as much as possible.
The legal status of two parties that own a property that aren't husband and wife, aren't joint tenants. Sometimes it's specified tenants in common. It was not specified, I think, by law. They're treated as though they're tenants in common.
Right, that's the default.
By default. And so, as a real estate agent, we have forms for that. There's disclosures for tenants in common to disclose. Is there an agreement? There's not an agreement. But it seems to me once you get to that point, now you've kind of set things up. If you don't have somebody you have a relationship with, you're setting up opportunities for conflict. But if somebody came to you and said, hey, I own this property with my cousin, didn't mean to because his father passed away, do you put together a tenants in common agreement? Is that something that you create as an attorney to help avoid that problem down the road?
Well, that's definitely a situation where people can involuntarily become partners, in a piece of real estate, siblings, cousins, that sort of thing. A big one is adult children with step parent, and that has its own fun aspects to it. You can certainly, when that happens, you can certainly then go and create an agreement as long as you're all in agreement.
Right.
You can create an operating agreement that applies to this property. You can, create an LLC and transfer the property to the LLC. I believe you could probably set up a trust. I think I'm stepping outside of my area of expertise a little bit, but you can, if you find yourself in that situation, as long as the other parties are willing to do it as well, you can certainly enter into an agreement.
And the agreement, I'm sorry, and the agreement will include the terms of dissolution, meaning usually a well-crafted agreement would say if one party wants to sell, maybe there's a right of first refusal, or if one party wants to sell, they get 2 or 3 appraisals and they calculate a number based on that, or whatever the agreement they both agree are. But the goal would be to set up a process in that agreement so that because inevitably one party is going to die or want to leave or want the money, and that would be in the agreement. And so in estate planning, sometimes properties are distributed, but there's no such agreement that goes along with it, right? And so it would seem to me the first thing to do would be to say, we better figure out how we're going to work on this together. Either we agree to sell it, or if we're going to keep it, we better have some sort of document that covers while we have it, and then when neither one of us want to get out of the deal, what does that look like? I had a recent case where a partner died. He had 2 different partners on 2 different properties, and the heir didn't want to be in real estate. He just wanted his money. These are very complicated properties in both cases. They both had tenant common agreements that both specified. Here's the process. You get an appraisal. They have to agree. If they don't agree, they have, there's the process. So again, is that something that somebody would come to you and you would create? Imagine, hey, I have a friend and we just both inherit this property. But we're concerned at some point. Everything's fine now, but at some point, I may need to sell out, or he may, or we may have, spouses. Can you put together a tenant common agreement? Is that something that you're able to do?
Well, I focus on disputes and litigation, and not so much on what I would call transactional work, which is creating contracts or shepherding transactions. I certainly can review agreements, on one side's behalf or the other. I have done that kind of work, but I wouldn't want to put myself out there and say that I want a bunch of people coming to me and creating these agreements. There are attorneys I know who focus on that area. As lawyers, we don't say we specialize unless there's a thing you can get through the state bar that says you're a such and such specialist. And so there are attorneys I know who focus on that. They may actually have a specialization, but it wouldn't be something that I would encourage people to come to me for, except for the fact that I could probably refer them to a lawyer who could help them.
And I'm going to say this, knowing Jack for 6 years or so, he has a phenomenal Rolodex. He's introduced me to some great attorneys on specific niche issues. Litigation, probate litigation was one. I'm trying to think, there was another one or two. Eviction, litigation, not the standard filing of the paperwork, but really it was like a war litigation. You introduce this to somebody. So Jack really has a great Rolodex.
There was one governmental agencies. I remember there was an attorney you were dealing with something having to do with the city, and there's an attorney I know who used to do lobbying.
Yeah, so he's really a great resource based in the Valley here in Los Angeles, but has a pretty robust network. And I would say somebody who really works his Rolodex to find out what the other referring entity does well. So he's referring to somebody who really does it well. I get asked all the time, "Well, I need an attorney. What do you need them for?" "Well, I just need to talk to an attorney." Yeah, that's not going to help you. And I think that really that's something that you've always played with me is really get down to what the issue is and try to find the right person. Another area that
it's also interesting. Something comes up a lot, especially in Facebook groups. But I spend a lot of time in Facebook groups. Is they say I need a real estate lawyer, right? And then they get referred to me, which is great, and I get on the phone with them, and I say, they inherited a piece of property, blah 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 blah, and it turns out they don't actually need a real estate lawyer; they need a probate lawyer,
right,
or an estate planning lawyer.
Right.
Just because it has to do with the real estate doesn't mean you need real estate. So I encourage people, instead of saying I need a blah 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 lawyer, or even that I need a lawyer, is because sometimes you don't need a lawyer to solve some problems.
Correct.
What you want to do is say, here's the problem I have, and you describe the problem, and the person who you're talking to, whether it be Bill or myself or somebody else, is like, oh, you need a surveyor, you need a real estate dispute attorney, you need a probate lawyer.
Correct.
Because you saying what you think you need is a lot of times you're wrong.
Well, it's like saying you need a certain type of surgery without knowing really what your disease is, and I think that, and that's something that, and also what state and county. If you're in a Facebook group, just those who are on that or any other network, because the laws vary by state and the procedures vary by county, and so there's a big difference between getting an attorney who does a good job on probate in LA County versus Orange, because the ones who do LA County know the judges, they know the procedures, they know the clerks, the probate attorneys review the notes, and it's a whole different world in Orange County. Not to say you can't do both, but generally it's not the same.
There's as many specializations or focuses in the law, I think, as there are in medical. When you're thinking about all the different kinds of doctors there are. Lawyers aren't just lawyers, just like doctors aren't just doctors. They have focuses.
I feel the same way as a real estate agent. I can sell anything from timeshares to the Golden Gate Bridge, but I don't do well with bridges. I don't do well with timeshares, but I do certain things really well, and I try to stay in that lane. I think for everybody, the other thing I've learned is the more narrow somebody's focus is, the more value they bring to their customers, because they go deeper, and that's really what the customer needs is the right deep solution, not just some off-the-shelf solution. One of the areas I know that you've helped people in, and I got involved with one in, is lot line disputes, property disputes. And so in estate planning and probate, you inherit a property, and it's not uncommon that the decedent kind of didn't pay attention to something for 5, 10, 15, 20 years, and then you find out, well, there's a driveway, but the lot line goes halfway through the driveway, or there's a fence, and half of the fence is on your property and half is on the other property. So talk about kind of common real estate. And I know you get involved in those lot line disputes, and what are things that people can do to avoid those disputes becoming bigger than they should be otherwise?
Well, there's two situations I'm going to touch on. One is when you're acquiring the property for the first time, not inheriting it. And I know that you're mostly having to do with probate, but let me touch on outside the probate area. I believe that within the next decade, one of the, if not required, one of the recommended things that's going to be done for every purchase of real estate will be a survey. And not just a survey showing that the property is a square or whatever, but a survey that shows the property lines in relation to buildings, driveways, trees, and fences,
In its
among other
current
things.
state, like an
In its
overlay,
current state.
like an overlay of a picture from top on top of the survey.
Exactly. It doesn't have
Yeah,
to be color. I've seen beautiful color surveys, but
yeah,
just something that tells you. Because my joke is on the west side, the fences are merely suggestions of where the property lines might be.
yeah.
I have a number of cases on the west side regarding fences and driveways. So there's a lot of shared driveways and there's a lot of property line adjacent driveways in the west side. So you get the survey, then you know that what you're looking at is what it is. Okay. If you find the fence is not on the property line, give or take a few inches, or if you find that the building is right up against the property line, or that the property line, like you said, is in the middle of your driveway, where I've literally handled that case, that helps your purchase decision, right? You don't want to buy litigation, right? So, the only thing worse than buying litigation is unknowingly buying litigation.
Correct.
You can make decisions with, knowledge is power. And so if you find that the property line is actually in the middle of the driveway, that's something. Now you got to go back to the seller. Did you know about this? Is there an agreement? Have you ever is there any litigation regarding that? Is there a written easement that hasn't been recorded? I mean, there's all kinds of things.
Right.
And if you find that the property line runs down the middle of the driveway and the seller had no idea, do you really want to buy that property, or are you going to go to the trouble of talking to the neighbor, or all those sort of things? So that's something I think is really important when you're buying property, is to know where the property line is and know where the physical objects are. There's a huge tree in
Correct.
the back, right? I had a
Your
case
tree.
where that tree was owned by 3 different properties because it was right on where the 3 properties came together. And so that opens you up for the rest of your life that you're owning this property. You're sharing this tree, and who's going to pay for it to be trimmed, and if it falls, all these things. But at least if you know going in, you can make
Right.
decisions. Okay?
Right.
Now, when you're inheriting a property, you also want to know those things. But then you have the situation where the fence has been there for 30 years, right? Or the driveway's been there for 30 years, or that building has been over the property line by a foot for 30 years. That opens a whole different chapter of the legal books of something called a prescriptive easement. There's other kinds of easements, but it's sort of the umbrella term that I use is prescriptive easement. My trial that I just got out of, it's not quite done yet. I actually have a hearing tomorrow about it. Is about a prescriptive easement, and something that's been there since at least 2006, and probably well earlier than that, maybe as far back as the 70s. So you want to know, I've inherited this property. Do I have any property line issues? And if I have these property line issues, what am I going to do about them? How long have they been there? And what's our relationship with the neighbors? And is this problem with the property line to our benefit or to our deficit?
Right.
And what does title have to say about this? If we go back to that's a whole other thing, because if you inherited, maybe title insurance from the decedent doesn't apply to you. And I'm not an insurance person, and people may be screaming at the screen right now saying, "You idiot, that of course it doesn't apply." I don't know. But those are questions you need to ask. But you don't know to ask those questions unless you get a survey and find out what's going on.
Well, and to your point, though, for sure, if you make a deed and don't get new title insurance, for sure you're not covered. I can say that
Right.
as a real estate agent with experience with title companies. I don't know the law, but I can tell you as a consumer of the service, and I can also say for sure, if you make a deed and you buy title insurance, then it is insured by definition. You get a policy and it specifies what's included and what's not included, and that's why I feel like so often in probate and estate, there are these deeds that are done, and they're not done as part of a transaction. They're not part of a insured transaction, and that just forces the issue down the road. And I think we're only getting more particular legally over time. So whatever issues you have are worse 10, 20 years from now. With technology, we can find these issues and debates, and so I think it's really important when you do estate planning, for example, you want to think about, you could deed it from the person into the estate plan, but now you have no title insurance. And you should think about that. Well, if you're also going to refinance, why don't you just do it all at once? If you're going to do a reverse mortgage, just do it all at once, and now you have title insurance on that transfer. And so these are things that, if they don't, they come back to Jack 5 years later as a paying customer rather than as a consult. So on lot lines, and then again, I guess, one of the solutions has been in a probate I dealt with. We had a conflict, or we had an issue with a lot line. We just disclosed it and sold the property as is. We disclosed it and said, "Here's what we know. Here's a prelim. Do your own survey. Do whatever you want. We think there's a problem with this. There was a fence issue with the city, where two parties were arguing over who was responsible for fixing it. And the truth was pretty clear to me that they both did. And my party said, well, I've been trying to get this guy to pay up all this time. And I had investors said, I don't care, I'll deal with it. And they bought it as is. So as long as you disclose it, you can get out of those issues and pass it on. And the flip side, I don't know if you get involved with this, if you have a easement or you have a agreement between parties, it was not common to record those things in the past. But today, I think it's really important to get those things recorded. So there's a history, public information is disclosed publicly. And then again, when a transaction happens, there's insurance covering that easement agreement or a common use agreement, whatever it is, that's part of the package rather than just some straight thing. Is that something you've seen? Is that good practice to get those things recorded?
Every one of my cases that resolves with a written easement, the easement is going to be recorded. Period. The end.
There you go.
I mean, it's not even an option to have a secret easement. It doesn't make any sense. It doesn't benefit anybody. But one thing that you said a phrase, and again, I'm stepping out of the probate area for just a moment. Use the term "as is," and I hear that come up from attorneys who don't practice in real estate a lot, or from developers and investors who don't understand. The term "as is," as used in real estate documents in California, doesn't mean what you think it means. And I'm not talking about you, I'm talking about the general public. It doesn't mean whatever it is, it's as is. You still have disclosure requirements.
Oh, yeah.
You can't commit fraud. You can't hide things. You can't purposely keep yourself not knowing things that you should discover, that sort of thing. As is means if there's a fence around the property, there'll be a fence around the property at closing. If there's as is means if there's a stove in the kitchen, that stove will be in the kitchen. It means you can't materially change the property.
Right.
It's not a waiver of warranty. It's not a waiver of any duty. Now, that is different if I'm selling you, for example, a watch. look, here's the watch. I'm handing you the watch. I'm selling it to you as is. I have disclosed to you everything I know about that watch.
Right.
Okay, that's a little different than selling a house in the term as is, because the transaction of selling a house takes more time than selling a watch.
Right.
Like, you typically don't escrow a watch.
Right.
And so you don't have as many moving parts. And so that as is sort of says, okay, you can't materially change the structure of the real estate while this transaction is going on. So what I saw when I came for the open house is what I'm going to get when escrow
Right.
closes.
Right.
That is a completely different animal from disclosing a leaky roof or bad electrical system or property line issue. That's as is doesn't waive that.
Right. But if you disclose it and say, I don't know if it's on the right line or not, here's the dispute, here's the letters, here's the history, here's everything I know, right? And during escrow, you can inspect everything you want, but you're buying it as it is. Meaning, here's all my disclosure, here's all the information. I don't want to tell you other than you're going to take it from there, whatever it is.
Right. You and I think I've used this term with you, or this phrase with you before. You can't be successfully sued for something you disclosed. Okay? So if you disclose it, they really can't sue you for it.
Right.
And I tell, when I'm advising real estate professionals, I give presentations and such. I tell them, if you're the listing agent and the seller comes to you and says, should I disclose? You put your hand up and you say yes.
Yes. Yes.
Because if they thought enough to ask you if it should be disclosed, just disclose it.
Yeah.
Right? If you don't disclose something that you discussed disclosing, that's going to come back to bite you, especially as the real estate professional who does this day in and day out.
Right.
Okay? You may sell 99 properties and not have a problem, and that 100th property where the seller came to you and you said, oh, no, we don't need to disclose that, it's going to come back to bite you.
Yeah, because why would you ever say not to disclose? It's because the buyer would back out if they knew that information. And so we're not going to tell them that because we don't want them to back out. Well, that's I don't know the legal term. That's a problem, right? That's not good. I had a client who didn't answer disclosures to the very end about whether the parent passed in the property or not. One thing that's common is people nowadays, for whatever reasons, want to pass in the family home with their families. They want to have a experience of some sort. But oftentimes, they're not pronounced in the property as having passed. At some point, they call the ambulance takes them to the hospital, and they'll put the place of death as the hospital. And by definition, they didn't pass in the house. You could say that. So how you disclose that? Well, you can disclose whatever. You should disclose whatever you know, whatever all that means. But it's good to have the death cert. If it says place of death, the hospital, it's good to have it. But that doesn't mean you shouldn't disclose that, whatever process you went through, the decedent lived in the house for the last 3 years and was under hospice and I just feel it's one of those things that you don't want to get around it to have it come back and bite you in the rear end. To me, it's just not worth that work. And in the end, in this particular case, he didn't want to disclose because he was afraid the buyer would back out. And the buyer at the very end was pissed and I got it, and I had to disclose it once he told me, and I did disclose it once he told me. I've learned now ever since to get the death cert day one, so I don't have to ask the question. I can just read it for myself and post it as appropriate. So again, it's one of those things where would you disclose if somebody did a hospice, but they were picked up in the hospital and pronounced at the hospital, not at the house? How would you do? Of course, is this your area of expertise that you feel comfortable commenting on?
Well, it's interesting. As you're saying it, I'm thinking to myself, they didn't die in the house. Now, what I would do in that situation, if a seller or an agent came to me and asked, should I disclose? The default is yes. But I'd go and research it, and I'd look at the actual wording of the law,
right?
Because that's a legal requirement. So I would look at the law and see what the law says, and make a decision that way. Uh, but let me a different situation is when my wife and I lived in our old house. Whenever it rained, there was a part of the driveway that would flood, and it was just a low point, and there really was not much you can do about it. So we had a sump pump put in. We had a big drain, probably 4 feet by 4 feet grid, and a sump pump down in a hole, and they dug a ditch all the way to the street, and it never flooded again when it rained. Okay, and when we went to sell the house, I disclosed that the reason why we put in that sump pump on this year, and the reason we put it in is because it previously flooded it. And I was comfortable with that. That's a little different than someone died in the house versus someone left the house and then died in the hospital. But it's a legal requirement.
Right.
But it was just like it was something that I was like, when you walk on this driveway, you're going to see this big grid on the ground. And it's like, okay, what's this about? And I thought I'll disclose it. I can't imagine that someone would not want to buy our house just because there used to be a flooding problem. But I didn't want to have to deal with it.
Right.
That we didn't disclose we used to get floods in that area. And it never went into the house. It was out in the driveway. But it was just, Now, I had another situation. I handled a case where the kitchen sink had a plumbing issue, and it caused a flood of water underneath the sink, that the father-in-law came over and cleaned it up, and he was a plumber or handyman, and he fixed it, and it wasn't an issue. They dabbed up all the water, whatever. 5 years later, they sell the house. Turns out the family they sold it to, one of the children had respiratory issues, and at some point they figured out that there was this flood under the sink, and the whole lawsuit was about this undisclosed flood
Right.
under the sink that took place 5 years earlier.
Right.
So fast forward to my wife and I buying the house that we're in now. We did a lot of work on it before we moved in, so no one was living here for 3 months. And one of our bathrooms has hardwood floors. And we moved in, and the first time we used the toilet, it overflowed because the pipes had dried up. And so we had this flood in the bathroom that it really didn't require anything other than dabbing up the water, and the hardwood floors survived fine. That's 18 years ago, and I still remember it. And if we ever go to sell this house, I'm going to disclose it. Just because it's something that someone has sued about, an
Right.
old flood. And it sounds ridiculous until you get sued for it.
Well, and that's why I recommend to sellers. The best practice is disclose it, put on your forms. As soon as you list the property, put the forms on the MLS. When they make offers, send them disclosures. When you're in escrow, open them right away, send disclosures. Get out to them right away as early as you can. My experience is people are not as careful. I'm not saying you're hiding it. I'm not saying you're doing anything dishonest. I'm saying do your job properly, early, prepare, and that's the best protection of your customers. Disclose it, but get it up early. When the last piece of paper is whatever you think you might want to hide, that's when they're going to look at it really carefully. And if they have an excuse to get out, you've now given them an excuse to get out. And that's what you don't want. Look,
Well,
Chuck, obviously
thing.
we can go on and on. I'm sorry, I've kept you a little bit over time of
Okay, sorry.
what we plan to.
I
So
was just going to say, if you're a real estate professional and you're selling a house that's in an HOA, you should get the meeting minutes and the CC&Rs and the bylaws before you even put on the MLS. You should already have those in your pocket.
yes, yeah, and nowadays it's so much easier than it used to be. Now with the internet, usually you just go online, you pay a couple $100 and you download it and upload it to the MLS, and they're all there. And tell people with an offer, you want them to acknowledge that they reviewed it, because they'll come back and say, "Oh, I didn't know I could have a dog over 5 pounds. It was in the rules. It was right there." So, yeah, again, I think what your good advice here is let's disclose everything as we can and do it as early as we can in the process. Fantastic. Well, somehow we managed to avoid talking about UCLA football, which is a point of contention with us. Jack LaPedis is one of the best attorneys in Los Angeles because of his Rolodex. He understands real estate agents, real estate investors, and other attorneys. And so if you're an attorney doing estate planning and have real estate issues, or you're a real estate agent, great guy to call. LaPedisLaw.com is the website, LaPedis Law, and then down below we have his contact info, and reach out to him. And then, do you still go to that Wednesday real estate investment meeting?
I was just there today.
How about it? How many people are there today at the Sizzler?
Today was about 10 people.
Okay,
It's been as many as it's been as many as 40 people, but a couple of the people who are running the meeting have some pretty good plans on how to advertise it more. So it should grow in the next
nice.
few months, I believe.
Prosperity Through Real Estate is every Wednesday at 11 at the Sizzler on Sepulveda and Van Nuys Boulevard, I
With
think.
Van Nuys.
Van Nuys Boulevard.
On Van
Great
Nuys.
meeting, and Jack was a regular there. That's where I met him through that group originally. So, Jack, thank you as always for educating, being available, being a great resource, and thanks for your time today on the podcast. I really appreciate it.
No, it's always great to talk with you, Bill. I hope to see you again real soon.
Thanks. And of course, you always catch Jack on Facebook at some UCLA football or basketball game, just in case you're wondering where he is, if not the Dodgers. Hey, this is Bill Gross, Estate Planning Weekly. We usually have estate planning attorneys, but Jack's a great resource when it comes to real estate and challenges in that area. So hopefully you got something out of that. If I can help in any way, please reach out at Bill Gross Probate on social media. And as always, make today your best day ever. Thanks so much.